We're going to turn next to Form FL 110, which is the summons. There's not much to fill out with this document, but there's a lot for you to understand, so we're going to go through it very slowly. You're going to name the other side, who is the respondent, here at the top of the page. Notice the respondent. And then under the sign "you are being sued," you're going to then list your name. You are the petitioner. I know it sounds funny, but anytime you open up a case, it is technically a lawsuit. So you are suing the other side for either a divorce or a legal separation. It's not as scary as it sounds. This first page applies to the other side, the respondent. It is giving them notice of their rights and their obligations, which means they have 30 days after the date they're served to respond to your petition for divorce or legal separation. The only things you need to fill out, number one, you need to list your name and address of the court. Number two, you need to list your name, address, and telephone number. The only other box you need to check is under A. You are suing the other person as an individual. They're not a corporation. They're not minors. You're suing them as an individual.
So which line did you say was supposed to have your name? Number two?
Number two. So number two has your name and your address and your phone number. Page 2 of the summons, this is what you signed under penalty of perjury when you signed your petition, is that you've read these standard family law restraining orders and that you understand them and that you understand that you are bound by them the date you file your petition. So page 2 of the summons. There we go. So it's that second block box called standard family law restraining orders. The first restraining order is that starting immediately, neither one of you can remove the minor children from the state of California absent court order or written permission from the other parent. They want to avoid parental kidnapping. The second restraining order, and this is one that most people overlook, you cannot change any insurance beneficiaries, whether it's health insurance, life insurance, or auto insurance. It doesn't matter. You cannot cut somebody off of any insurance policy between now and the date of dissolution, the date of your divorce. Your job will prohibit you, for the most part, from changing the beneficiaries on your retirement plans and on your life insurance policies, but things like health insurance, they're not going to necessarily stop you. This is a warning that you cannot do so. And it works the other way. If you are on the other side's health insurance benefits, they can't cut you off either. Number 3, you cannot destroy or hide or do anything funny with your property, whether it's community or separate. They basically want to kind of take a snapshot, a freeze frame. They don't want things to change. They don't want anyone to do anything funny with the money. They don't want anyone hiding assets. They don't want anyone destroying assets. You leave things as they are, with the exception of the basic reasonable expenses to cover your normal living conditions. So if you have an average middle-class lifestyle, that doesn't mean you get to suddenly go spend, and say that's my basic living conditions. And you do not need to live like a pauper either if you have a middle-class existence. All right. Number 4 is that you basically can't gift away the property. A non-probate transfer is kind of funny or fancy language for saying, if I own a house, I can't sign a quitclaim deed and give it to my mom just to avoid having community property. They don't want you doing anything like that. Again, the idea is social niceties, being nice during the divorce, not hiding anything. Any questions on the standard family law restraining orders?
I remember, so the number 1 on the other page, and that's just Martinez Superior Court of Martinez?
That's correct. Same.
And the address?
Same address, yes. You're going to fill that out a lot.
Okay.
Any other questions?